2024, when the accused persons took plea. I am on record having informed courts that inquiries were complete. However, Your Worship, on the 9th of July 2024, there was an application by the accused persons to be released on bail. However, Your Honor, I wish to inform courts that the application for bail has been overtaken by the events. Your Honor, what events am I talking about? We are seeking leave to amend the charge sheet in accordance with section 132, subsection 1, paragraph A.
Section what?
132. Of the Magistrates Court Act.
132?
Your Honor, that section allows us to amend the charge sheet we have since discovered that this case discloses other offenses Count 1 of the charge sheet, we are maintaining diversion of public resources against A1 Mawanda Michael Maranga, However, we are introducing an alternative count of receiving stolen property. Your Honor, in count 2, we are still maintaining diversion of public resources against Honorable Mudemi wa Makuyu Ignatius, Honorable Mudimi wa Makuyu Ignatius. However, we are introducing an alternative count of receiving stolen property. Your Honor, in count 3, we maintain diversion of public resources against Honorable Akamba Paul, but we are introducing an alternative count of receiving stolen property. Or we maintain diversion of public resources against Kiria Julius Taitankoko, Julius Kiria Taitankoko. However, Your Honor, there is an alternative count of stealing by agent.
This is an additional count of money.
Your Honor, we are adding another count of money laundering against Julius Kiria Taitankoko. We are further adding another count of abuse of office
Who did this correct it?
against Kavundira Leonard. In count 7, there is another added count of abuse of office against S6 now, Sally Busurwa Geraldine. We are also adding another count of causing financial loss against Busurwa Sally Geraldine. She has also been, Sally Busurwa Geraldine, she's also been added in count 9 now, conspiracy to defraud. Your Honor, I know that A6 is not yet here, but I'm aware A6 is interacting with the detectives. And given tomorrow she will be able to plead to the charges. Your Honor, my amendment doesn't prejudice the accused persons because This is still at the preliminary stage of this case. We pray that your amendment be allowed. I pray that my amendment be allowed and the accused plead to it. Charge sheet.
For the record, for A2, Your Worship, we just want to find out from court, the court record. We heard that the amendment was brought under section 132, 1A of the Magistrates Court Act. So we just want to find out whether that is the position. We oppose this application on 3 fronts. The first front is that this section is not applicable and cannot be invoked by the prosecution to cause an amendment. For clarity, the section reads as follows: amendment of charges. Amendment, section 132, amendment of charges. Clause 1 A states that where at any stage of a trial it appears to a magistrate's court that the evidence discloses an offense other than the offense with which the accused is charged, and then the court, if it is satisfied, that no injustice to the accused will be caused thereby, may make such order for the alteration of the charge by way of its amendment or by the substitution or addition of a new charge as it thinks necessary to meet the circumstances of the case. Then the court, if it is satisfied that no injustice to the accused will be caused thereby, may make such order for the alteration of the charge by way of its amendment or by the substitution or addition of a new charge as it thinks necessary to meet the circumstances of the case. My Lord, Your Worship, this section applies where evidence has been adduced before the court, where witnesses have testified and adduced evidence before the court, in a trial, and the court discovers that evidence which has been adduced before it, and the court discovers that evidence which has been disclosed before it, or adduced before it, discloses another offense other than the one with which the accused is charged. That is the literal meaning of the section. The evidence, that is the literal meaning of the section. The evidence must be adduced before court. And such evidence has not been adduced before this court because no one has testified. So, how is this court going to know that there is actually a different offense which has been disclosed? And because, Your Worship, the legislature did not take the rights, because the legislature did not take the rights of accused persons who have been charged lightly, because the legislature did not take the rights of accused persons lightly, even where an alteration is made, under clause 6, that's 132(6), the prosecution can actually pay costs. That's the import. And the intention is clear: to avoid abuse of court process. And this is what is happening before you now. To avoid abuse of court process, and that is what is happening before you. And that is what's happening before you. Therefore, the application under section 132(1)(a) of the MCA is improper and the section is not applicable in the circumstances. The second front, Your Worship, is the statement that the application for bail has been overtaken. Your Worship, even if there was supposed to be an amendment, it is not supposed to deprive the accused persons of their right to apply for bail. You compliment. Your Worship, Article 125, Clause 5 of the Constitution of the Republic of Uganda enjoins the Director of Public Prosecutions the Director of Public Prosecutions in exercising her powers under the article to have regard to the public interest, the interest of the administration of justice, and above all, and the need to prevent abuse of legal process. The need to prevent abuse of legal process. Your Worship, we submit that there is nothing more than abuse of legal process than what is taking place before you by the prosecution now. They sought an adjournment to verify documents. They sought an adjournment to verify documents submitted by the applicants for bail, and the record of this court is clear that today they were supposed to come and respond or reply to the bail application. Instead, they've come to court and made an application under section 132 1A of the MCA,
which is inapplicable,
knowing very well the section is inapplicable, just to defeat these people's right to apply for bail. That is abuse of court process. Thirdly, they've added somebody who is not in the dock. That's another aspect of abuse of process. What does that mean? Will it inhibit the fresh plea taking. Your Worship, this is a court of justice. Article 126 of the Constitution derives its power from the people and under clause 2, Article 126(1) of the Constitution, this court derives its power from the people. And in clause 2, in adjudicating cases of both a civil and criminal nature, the court shall, subject to the law, clause 2, that's 126(2), the court shall, subject to the law, apply the following principles. A, justice shall be done to all, irrespective of their social or economic status. And B, justice shall not be delayed. Above all, Your Worship, justice shall not be delayed. Above all, under Article 28(3)(a) of the Constitution, every person who is charged with a criminal offense shall be presumed to be innocent until proved guilty or until that person is guilty. Until the person, Your Worship, these people are presumed innocent. But the state is treating them as if they are guilty by bringing applications in bad faith to deny them their right to apply for bail. So we pray that you be pleased to disallow this application, which has been brought in bad faith. These people will be prejudiced. The accused will be prejudiced. Very gravely. They have been in incarceration for over 1 month. Yes, almost a month. They have a pending bail application before you. And they have a right to apply for bail, by the way. They have a right to apply for bail. Their freedom has been inhibited. Their liberty is at stake. There's no more prejudice than that. depriving them of their temporal liberty. We pray that you disallow this application and order the prosecution to respond or make a decision on the application. You order the prosecution either to proceed with replying to our application. If they are not ready, or if they don't want, then, Your Worship, you can make a decision because there's an application before you. You can make a decision on our bail application. We so pray, much obliged. My colleagues have one or two things to add on. Thank you.
Oh, maybe I finish for A2 first.
Your Honor, Balak has said, but I will only make 2 points. Your Honor, the first one is that under Section 132, subsection 1, the reading is that if it appears to a magistrate's court, if it appears to its court, Your Honor, the interpretation section defines magistrate's court to mean any court established by or under Section 3. The interpretation section defines what a magistrate's court is. Therefore, Your Honor, it is not open to the prosecution. This section only applies to the court moving itself, not the prosecution moving the court.
It moves itself at the trial. It moves itself at the trial.
Your Honor, that is why the other sections talk of recording evidence, and therefore it means a trial must have started. And the court, on its own volition, realizes deficiencies. Your Honor, that is why under subsection 6, the court may order the prosecution to pay costs. The order for costs in my view arises from the punishment by the court meted to the prosecution for having done a shoddy job. So, Your Honor, my submission is basically that the prosecution cannot move under this section to amend the charge. It is only the court on its own volition after evidence has been, because the evidence must disclose, the evidence discloses an offense other than the one which has been charged, or the charge sheet is defective. It is only in those stages that the court can move itself. So I associate myself with my learned friend and submit that the court, only the court and not the prosecution, can move under that section.
I wish to just point two aspects to court. First, I agree with the interpretation given by my learned colleague for A2. I agree with the interpretation given by my learned colleague, Mr. Barnabas. That the entire section 132 is not available to the prosecution. The entire section. I know you will consider this, but when you look at section 132, the amendment can only be triggered on three conditions. Three. And those conditions are found on section 132, 1A, B, and C. They have moved on A, so I'll restrict myself on A. But I wish court to point to note that the rest of the sections under 132, the rest of the sections under 132 that is subsection 2, subsection 3, 4, 5, up to 6. Make reference to subsection 1. The rest of the sections make reference to subsection 1. Yes, it is therefore our submission that my submission that the interpretation of the whole section 132 the amendment can only be triggered by court and not any other party. Your Worship, when we came today, you did not tell us that it appears to you under that section. You did not tell us in satisfaction of that section that it appears to you or to the court. That the evidence discloses other offense, because there is no evidence before you. You did not tell us that. So where the court, you have not told us that, you cannot invoke that section. Your Worship, I agree with the rest of the submissions, but I also wish to point as follows. That joinder of parties in a charge is a question of convenience. Each of these accused person is entitled to be tried singularly or jointly for convenience. The introduction of a money laundering charge on another person. The introduction of a money laundering charge on one of the accused persons cannot be used as a stepping stone to prejudice the others. Because each of them is in court singularly. That is why you can acquit the rest and convict one, because each stands alone. Your Worship, we ask court to exercise its powers judiciously as an arbiter to have the prosecution either respond or you consider that the application is not opposed and the submissions made, you rule on that. I so humbly submit.